Thank you, Glenn. Good afternoon. There's been a recent development at the SEC in that the Enforcement Division, for the first time, has published what's called the Enforcement Procedures Manual. This is a very significant event in the life of the Enforcement Division because up until now, there's been no published procedures regarding how the division operates. And in the first instance, I think we should all commend the enforcement staff for putting this out because it adds a significant amount of transparency to exactly how the enforcement staff operates. One particular portion of the manual deals with the question of privilege and privilege waivers and cooperation credit, which has long been a very hot topic of debate for the last several years. And the SEC has put out a release several years ago called the Seaboard Release, which talked about this. The staff has put out various speeches at various times, but this is the first time that the staff has really crystallized its views in one place, and that's one of the significant aspects of this new manual. And I would break this down into really two parts. There's what it says, and there's what it doesn't say. And what it doesn't say may be more significant than what it says, but let's start with what it does say. What it does say, for the first time, and this is a new policy, is that the staff should not ask corporations for a waiver of the attorney-client privilege or the work product doctrine. That's a very significant event because up until now, there's never been any statement like that from the SEC or from the staff. All they've talked about is the possibility that there may have to be privilege waivers. The rest of the portion of the manual that deals with cooperation credit then goes on to reiterate the staff's long-held positions, that is, that you don't have to waive privilege to get some cooperation credit, although it doesn't define how much, and it focuses on producing the facts. But the bottom line, when you really read between the lines to what the manual says is, I would suggest there's really what I call a hard edge to this disclosure, because for the first time they make it really clear that while you may get cooperation credit if you don't waive privilege, it's going to be precious little. And that's why I say it's a hard edge. This is the first time they've really pushed it this far. If you really want significant cooperation credit, you're going to have to waive privilege. Previously, their policy was if you really wanted to try to get a pass, that is, not get prosecuted, you'd have to waive privilege. Now I think they've slid the scale even further. But take a look at the second point here, and that is what the manual doesn't say. And this is as significant as what it does say. And recall, the Commission and its staff have had the opportunity to watch the so-called waiver, culture of waiver issue develop over the last several years. Since they published Seaboard in 2001 talking about cooperation credit, they've watched policy after policy from the Justice Department get criticized in the media, get criticized on Capitol Hill, and would come to the brink of legislation passing on the Hill. During that time, not much has been said about the SEC, and they haven't really modified their policies as the Justice Department has. So they've had the opportunity to watch. So I'd submit it's disappointing to see that in their new policy manual, it says nothing about privilege. It's in terms of how important it is to the company and how important it is to its employees. While the manual does reference the notion that most facts that a company would have to give to the SEC for cooperation credit would come for an internal investigation, and that most of those facts would come out of an investigation where large parts of it are privileged, it says nothing about the importance of this process. And it is an important process, and the assertion of those privileges is important not only to the company, not only to the individuals, but also to the SEC, because the assertion of those privileges allows the company and its employees to collect the facts in a privileged setting, away from the glare of the media, away from the spotlight, and to introspectively look at what's happened, assess what needs to be done, take the remedial steps, and then move forward as a good corporate citizen. That's exactly what the SEC wants. That's exactly the goals of law enforcement. By ignoring those policies and just pushing for the notion that they want all the facts, regardless of the cost, they really ignore the very important underlying policies here, and they've really missed, in my view, an opportunity here for them to work with the corporate community, for them to work with organizations that want to be good corporate citizens and want to work with the SEC. They've missed this opportunity. So the bottom line to the manual is it's a good piece of work on the Enforcement Division. It gives everybody something. It gives a directive that says the staff won't ask for privilege waivers. But that's never been the real issue. The real issue has always been the pressure to waive privilege imposed by the prosecutorial system. Here, the hard edge that I mentioned ratchets that pressure up. So we have not only a missed opportunity, but more pressure coming out of this manual on corporations to waive privilege and undercut those very important rights.